My name is Robert, and today I will be your host. But before I can introduce you to the expert, let me go through some housekeeping matters. The webinar will last for approximately 30 to 45 minutes. It is designed to be interactive, so please ask questions. You can do this through the chat function on the top right of your screen. Our moderator, Kiki, who is sitting next to me, will pass your questions to me, and I will see it here on the screen. And the webinar is being recorded and will be shared with you later via the email. Okay, so let's start. So 2 years after its initial implementation, the EU Whistleblowing Directive remains a puzzle. Different countries have different requirements. What works for one company does not necessarily work for the other company. Conformity does not necessarily mean effectiveness. So before we can be effective, we need to be specific. That is why we teamed up with Dentons to discuss the directive and its implementations in the Netherlands. And today we are joined by Johanne Boelhouwer, partner at Dentons. She is here to help us understand the implications of the EU Whistleblowing Directive for organizations in the Netherlands. Johanne, welcome. So tell us, what is the EU Whistleblowing Directive about and whom does it protect?
Thank you for your lovely introduction, Mark, and thank you for having me. I think it's good to, before I answer your question, to say that I'm a lawyer specialized in employment law. So I think that's where I'm having a focus a little bit. So if you would have questions from a different angle, I'm trying to answer, but love mainly the employment law work. So good to have that in mind. And then to answer your first question, there are also two angles, because you're asking me whom does it protect, not only the companies itself, but especially, of course, the reporting persons, the whistleblowers. So under the rules, the new rules, I must say, larger companies will have to establish a safe reporting channel, and they have to diligently follow up on the report within 3 months. So the rules also protect not only the company, but also the whistleblowers from liability, but also against retaliation, which is a difficult word for me as a Dutch person to pronounce. National authorities are required to follow up on those rules and also inform citizens about their rights under this directive, and to, in fact, assist whistleblowers in their reporting. And basically, the directive harmonizes whistleblowing legislation in the companies in the EU.
All right, thank you. So you just mentioned what the EU Whistleblowing Directive is about and whom does it protect. So who does the EU Whistleblowing Directive concern?
So it protects whistleblowers, and this protection extends to people helping the reporting person, such as you can think of colleagues or relatives. And protection is also provided to self-employed workers, trainees, volunteers, but also shareholders and persons belonging to sort of the administrative, management or supervisory body of a undertaking that reports a breach. So that's for the person side. And then you have the company side. The directive applies to companies with more than 50 employees, and they need to apply or comply with the law.
All right, thank you. I hope that's clear for all the people watching the webinar. And if not, please ask your question. So, Johanne, have we already crossed the deadlines?
So there are a lot of deadlines. The most important one is, of course, coming from the directive. The implementation date of the directive is already passed because into the national system, I must say. The deadline was the 17th of December 2021. And for the Netherlands specific, the Whistleblower Protection Act, in Dutch it's called de Wet Bescherming Klokkenluiders, needed to be amended in order to be in line with the EU Directive, of course in Dutch law. And so there was a legislative proposal submitted to the Dutch House of Representatives on the 1st of June 2021. And that was passed on by the Senate in the 1st of January, no, the 24th of January, I must say, 2023. And it entered into force on the 18th of February 2023 for organizations with more than 49 employees. And I mean, the immediate entry into force of that act on a Saturday, you can imagine, was quite striking, because after all, the Dutch Parliament or the debate in the House of Representatives took almost a year and a half, and then it was formally adopted by the Dutch Senate in one day without any debate. And after that, it has been quite a silent. And the minister in the Netherlands only stated that new law will become into force in terms of penalties, but we'll talk about that later. But I think there's for compliance dates, it's important to keep in mind that the size of the entity is important. So organizations with more than 249 employees, they have to comply as per the 18th February 2023. But I know there are lawyers in the Netherlands, they say that that it's ambiguous. They don't know if that date is very clear, because it entered into force without any debate, and the minister has not been very clear on the entry date. To me, I think I would be advising my client to be compliant as much as possible, and the enter date was 18 February 2023. But I know that there are others who have a different opinion. And then to go back to the organizations with medium size, so between 50 and 249 employees, they have to comply before the 17th of December 2023. So although that implementation date has not been met, there's a difference with employers in the public sector and employers in the private sector. So the directive will only apply after the implementation in national law, which is for the Netherlands, the 17th of December 2023, or 18 February 2023, depending on the size of your company. And new legislation has been communicated by the Dutch minister, expecting to enter into force in midst of 2024, relating to additional rules for anonymous reporting, penalties, but we'll get into that in further detail later on this webinar.
Thank you, Johanne. So there are a lot of dates, a lot of numbers. Again, we are recording.
Yeah, sorry for the technology, the administrative part, but it's good to be aware.
Definitely is. And I wanted to say that it's being recorded. So if you think later on, so what were the dates again or the numbers, you can have a look at it later. So what obligations does the EU Whistleblowing Directive actually create? Or maybe more specifically, what are the exact requirements when it comes to the internal whistleblowing mechanism?
Yeah, thank you. Good question. So employers must establish an internal reporting policy and reporting channel if they don't already have this in place, because I see sometimes clients that also already have it. But if you don't have it, you have to be aware of having such obligation going forward. And the internal policy, reporting policy should, amongst others, include obviously the officials to whom the reports can be made, in what manner reports can be made, for example, in written form, but also through telephone or a voice message, even, or in person, followed by the deadline of the response, when there is a wrongdoing, whether there's a wrongdoing or not, and who may make the report within the organization. And in addition, the policy may include wording about prohibiting direct external reporting, but I mean, we see that at the moment, but it's good to be aware that that's no longer allowed. But we'll also talk about that later on, so I don't want to dive into much detail yet. So that's in general where you have to think about.
Thank you. So the next question that I would like to ask you, Johanne, is, so what are the requirements for acknowledging receipt and getting back to the reporter?
Yeah, so I think there's good to have a distinction between the directive and Dutch law. So according to the directive, the procedures for internal reporting and following up include, for example, acknowledgement of receipt of the report and the complaint to the reporting person within 7 days of receipt of that report, and then you have to, as an organization, respond within a reasonable period of time, so provide feedback. And according to the directive, that has to be not exceeding 3 months from, again, the date of acknowledgement of the receipt. Or if no acknowledgement was sent to the reporting persons, 3 months from the expiry of the 7-day period after report was made. Because you can imagine that if you don't follow up on the 7-day report, you cannot rely on that 7-day period as well. So the Dutch law is corresponding with the first days of 7 days. But the second part is slightly different, because our national law states that the reporter should receive information on the assessment and follow-up of the report within a reasonable period of no more than 3 months from the acknowledgement of receipt, and the report must receive an acknowledgement of receipt. So there's a little bit of a difference, but you have to, I think that's again a bit lawyer talk, so it's good to think about 7 days of receipt, a reply of the receipt, and then follow it up within 3 months. So 2 important time frames to keep in mind.
Perfect. And in the meantime, Johanne, I see a lot of questions coming in, so please ask them. I will ask them to Johanne a little later. The question that I have then, the $1 million question maybe, is what steps do organizations need to take to comply?
Yes, well, you're talking to a lawyer, so sometimes you also have to think about, do you need to comply at this moment? Because we see a different range of approaches amongst our clients. For example, by a wait and see approach, because it's new law, we don't know yet if what the sanctions are. So a wait and see approach, or a very proactive implementation. So the predominant trends are wait and see, whereas as applicable, companies are applying global whistleblowing policies, for example, without adaptation or a country addendum, specifically, for example, for the Netherlands, France, etc., or proactively implementing the core requirements of the directive itself, even though the local position is unclear. And then you do have organizations that want to comply as much as possible. But there are different flavors. And I think for the Netherlands, it's good to be aware that most employers will not have yet adjusted their internal reporting procedures in accordance with the new law yet. And in doing so, it's also important to be aware of the employee representation body position, because they must be involved as well. then you always, if I talk to people from abroad, for example, America, Canada, they're quite surprised about the position of the Dutch Works Council. And that's exactly where I'm talking about. They have quite a lot of power. So for implementation at the company level, if you do have a Works Council or a different form of employee representation, a so-called personeelsvergadering in smaller companies, they would have to give prior approval before implementing, amending, or changing the whistleblower policy or system.
Mm-hmm. So, and you mentioned the wait and see approach. I think the next question is more applicable to them. So what happens to companies that have still not complied?
Yeah, so that's why I said you don't have to be the smartest kid or the best kid in class yet. Not saying that you don't have to do anything at the moment, of course, but it's good to be aware that the investigation department of the House of Whistleblowers, so the Dutch authority with respect to whistleblowers, may impose a fine or penalty on the employer if the employer fails to comply with the obligations regarding the establishment of such internal reporting channel. But there are no penalties or sanctions yet. So the state secretary, I guess it's the state secretary, just thinking out loud, anticipates presenting a new bill for the implementations of the sanctions by mid-2024. I guess I already talked about that in the beginning of this webinar. Mm-hmm. So until then, you don't have to expect fines. But of course, there are, if you are already having the obligation to comply and people start reporting, and you are confronted with a whistleblower, then it would, of course, be good to have a policy in place and know how to follow up with it. So the precise approach for this will be further elaborated upon in the near future, and I will be definitely writing alerts on our website to keep people posted. So a little bit of advertising. If you want to know more, please follow the things I'm writing about.
Will do. Thanks, Johanne. And then, well, you mentioned this briefly, but just to make things clear, are the rules the same for all the EU member states?
No, because then it would be very easy, because the directive does differ from, for example, Dutch law. The directive harmonizes legislation in the EU, but for example, the Netherlands was one of the 9 EU member states, of which the EU Commission already considered having a comprehensive whistleblower protection with a country-specific legislation. And you can imagine, if there are 9 different states with already national law in place, there are quite some differences amongst these across these systems.
Mm-hmm. All right, thank you. We briefly mentioned the Netherlands a couple of times. Let's zoom into the Netherlands a bit more. So which new protection measure provides the Dutch Whistleblowing Protection Act?
Yes, it's good to be aware that the name changed recently. So we're now talking about the Dutch Whistleblowers Protection Act. Again, a bit of a lawyer talk, I guess, because it doesn't change the system itself, but it's only a name change. So to answer your question, for example, whistleblowers are no longer obliged to first submit a report internally. The retaliation prohibition has been expanded. Persons who can submit a protected report, as well as the definition of protected reports, have been expanded. There has been introduced a prohibition on silencing reporters. And there are stricter requirements applying to the internal reporting procedure itself. For example, relating to anonymous reports, deadlines, and mandatory registration of reports. And as said, the investigation department of the Dutch House for Whistleblowers, Huis voor Klokkenluiders, has also been given the power to give sanctions, including imposing fines, which are the amounts not known yet, in the event of retaliation, failure to follow instructions of the House, or in absence of such internal reporting line procedure. So quite a lot. I've been talking quite high level, so there's much to say about each specific topic, but I think it would be good for now to look at the key changes. And I think that one of the most important changes is the swift in the burden of proof, because the employer will have to prove that the disadvantage suffered by the reporter is unrelated to the report. So there's a reversal of the burden of proof that applies at the moment, because according to current law, the reporter themselves must prove that they have been disadvantaged because of the report. But going forward, the burden of proof no longer lies with the disadvantageous person themselves, but with the employer. And I think that's quite a big change. But in my view, the most important and far-reaching change is that reporters will be given the opportunity to report directly externally, so outside their organization. So at the moment, there is still the obligation to report internally first, and an external report can be made if to a competent authority, designated in the Act, and we'll talk about that later. But a reporter may also make a report public in certain circumstances, for instance, through the press. And these changes mean that whistleblowers can make a report of wrongdoing outside the organization without, in fact, the organization being aware of it themselves, or itself, I should say. And then the Act also provides for several protection and support measures in order to protect the reporting persons against retaliation, I love that word, such as dismissal, suspension, transfer to another company, of course, or harassment. And that prohibition of detriment, so no detriment to the reporter, includes any form of detriment against the reporting persons, including threats or even attempts to do so. Then one point before I stop talking about this is that the Act currently only provides protection for former or regular employees and public servants. But as mentioned in the beginning, this protection will be expanded to a broader circle of persons, as referred to in directive. So that's where now the Act becomes more compliant with the directive. And then we talk about self-employed persons, shareholders, board members, facilitators, interns, but also third parties closely associated with a reporter, such as colleagues or even family members. So I think that's also a very extensive or important change. Even the fact that the memorandum to the legislative proposal, again, lawyers love reading those kinds of things. It specified that it also includes confidential advisors and trade union representatives. And then, as I said, I start stop talking now because it's a lot, maybe also to digest.
I can imagine
Yeah.
also. So maybe, I don't know if you have any water, but please take a sip of it. Indeed. So thank you for being so specific on the questions. So the last question that I have to you, and then we go on to the questions from the viewers, is so what has traditionally been the role of trust persons in Dutch organizations? And how does this balance with an anonymous reporting channel?
Yeah, well, that's a very interesting one because, well, you have confidential advisors. They are there for employees, who have reports within the organization or complaints about undesired behavior. You can think about aggression, harassment, bullying, discrimination. And the duties of such confidential advisor or trust person include then finding out what happened, if there are any solutions possible, and informing the, let's say, victim about them. So also providing education, in fact, on how to deal with this behavior. And then there's an obligation to handle these matters confidentially. So there's a duty of confidentiality. And then there is another legislative proposal in the Netherlands in the House of Representatives. And it has agreed that for employers who have at least 10 employees to appoint such trust person within the organization. So the bill gives employees a legal right to access such confidential advisor and also strengthens the position of the confidential advisor within the organization. The exact timing of the date is not, the implementation date is not yet known. It's submitted to the Dutch Senate, the bill, but we'll have to get back on the exact date. And I think one of the most important questions for employers at the moment is what the role of this confidential advisor, I mean, I get that question a lot, could be combined with the role of the independent reporting channel, since these two roles represent conflicting interests and could therefore be considered, incompatible. And I can imagine that the listeners have questions around this, so I stop talking for now, but I have also thoughts about this process as well.
Thank you. That were my questions. Let's go over to the questions that you asked. Therefore, I need to look at my screen in front of me. So, Johanna, the first question is coming from Sandrine. She's asking, so the number of 249 employees that you were talking about. So how is that relevant in case a group of companies has less than 249 employees in the EU, but more abroad?
Right, then it depends what abroad is, because the directive only applies to companies in the EU. So I get this question from clients as well. If they're outside the EU, I guess that's the most typical situation. You look at the obligation, for example, the Netherlands only. So you don't look at the situation outside of the EU to be compliant.
Okay, thank you. I hope that gives answer to your question, Sandrine. The other question is coming from Sarah, and she's asking, when we say employees, does it take into account also consultants, employees of records? How about NGOs?
Are you employees, or can you repeat the first part?
Yeah, so when we say employees, does it take into account also consultants, for example, or contractors?
Yes, and also employers of record, so that they're not hired formally by the employer, but within with another company, but working at the company that has to have the reporting channel in place. I would say so, yes, that it's not that a formal criteria. But again, that's also informal versus material rule, and that can differ per jurisdiction. But I guess for the Netherlands, you have to look at the persons working in the organization.
Okay, thank you. Then a question coming from Jeffrey. If someone, in this case, I think an employee, made a report via phone, is it still required to send a written acknowledgement of receipt?
If you have that in your policy, yes. But it's an allowed way of reporting something by phone. So as an organization, you cannot simply ignore saying you only did it by phone and not in writing. So new law also allows to do it by phone.
Okay, clear. Then Casper, next question, is asking, is a reporting desk at group level sufficient? Because we are a group company with activities in 18 countries.
Wow. Yes. Yes, I guess so. As long as it's independent. And then it's the question of whether it's an independent or not, and what the role is of that desk. I mean, if it's the same, will it also do investigations, or it really depends on how the desks look like. But in general, I would say that one point of entry is possible, yes.
Mm-hmm. Thank you, Casper, for your question. And I see a last question at this moment from Mathilde. She asks, changing an existing whistleblowing policy to add anonymous reporting as a channel, does this also require Works Council approval?
Can you repeat it again, please?
Yeah, changing an existing whistleblowing policy to add anonymous reporting as a channel, does this also require Works Council approval?
I would say on the basis of law, yes. But it also depends on arrangements with the Works Council in place, because sometimes there are specific arrangements with Works Councils looking at topics that either do or do not require consent. But without any further context, I would say yes.
Mm-hmm. I see that Sarah asked two questions. The other one is, you might have pointed out a little bit, if the organization has multiple offices, so not branches, but simply rented office spaces, will it need to follow also local regulation or only the Dutch one?
What is the difference between local legislation and Dutch one? You mean in other countries?
I think so, yeah.
Yes. Yes, I would say you have to comply with the both ones. And that's where it becomes really difficult. And that's also why you see there's a general approach at this moment. Either you have this worldwide whistleblowing policy with, for example, country-specific addenda, versus an either really national compliance system or no action at all. Mm-hmm. So there are different flavors at the moment, and that's also why you see that some companies only do the bare minimum and have a little bit of a laid-back approach to start with. Mm-hmm. And maybe, I don't know, Mark, how much time we have left?
A couple of minutes left.
Okay, so do you have any other questions, or
a last one?
Okay.
So the last question is, and maybe I can answer that better, but what core functions should an ideal whistleblowing software offer for the EU directive?
Yeah, you should answer that one.
I think
to make it easy for myself, but you have a much better view on that.
I know by heart it should be first be anonymous reporting. Obviously, provide secure and a comprehensive data management, multilingual support. I would say case tracking, really important, Stephanie. And also provide, I would say, analysis tools to identify trends and patterns. That's one thing we see very, very often. And also to make it, to lower the barriers in the first place to make a report. I hope that answers your question, Stephanie. Yeah, like I said, that was the last question, Johanna. So thank you all for watching the webinar. I can imagine that after the webinar, or if you have a second look at it, there might pop up some other questions or thoughts. I also asked Johanna, will you be able to also help us out or help the viewer out later on? Her answer was yes. So if you have questions, concerns, or help, let us know. We will send you an email with our contact details. Also, within the email, we will share you a recording of this. And again, do not hesitate to reach out to us. So I hope we gave you some insights on the EU Whistleblowing Directive and how you can turn that into an opportunity. Also, later on, we will share an ebook with some more information on this. Thank you, Johanna, for helping us out and answering all the questions that we've asked you. And you, as a viewer, thank you very much for watching the webinar, and I hope to see you next time. I wish you a wonderful day.